All right, welcome back, everyone. Thanks for jumping on the QX Financial YouTube channel today. My name is Nathan Bigley, financial professional with QX Financial. And if you get something great out of this video today, please share it with your friends. Give us a comment on what you liked about it. Even leave us a question of maybe something we can address further in our later videos. And yeah, enjoy the video today. We're going to be jumping into deeper forms and different details of asset protection with estate planning professional Phil Shekerlian joining us once again. How's it going, Phil?
I'm doing great. Thank you for having me again.
Of course. So I understand we're going to be talking a little bit more in detail about something we mentioned on a previous video, which is asset protection.
Absolutely. Yeah. We've talked about some types of asset protection so far. We're going to talk about using irrevocable trusts for asset protection in this video.
All right. Cool. So if you guys haven't seen it already, we did a video on irrevocable trusts. So after you watch this one, make sure to go back and catch that one. Phil provides a lot of fantastic information. So
excellent. All right. So there's many types of irrevocable trusts out there that can be used for asset protection. I'm going to talk about two of the most common types and go into them in a little bit of detail. The first one is something called a domestic asset protection trust, also known as a DAPT, D-A-P-T. They are an irrevocable trust. They can be set up to benefit the person that creates the trust, or they can be set up to benefit a third party. So for instance, I could set up a irrevocable domestic asset protection trust and put in all my assets, or I could set one up and we could transfer, I could set one up for Nathan, and Nathan, you could transfer your assets there, and then you have protection of your assets in the trust that I set up. The reason to do it either of those two ways depends a lot on control and ownership. If you want to be in control of your own, then you should set it up on your own. But then you're not the owner anymore of your assets. Somebody else is. In the converse, if I wanted to be the owner of my assets but not be in control of them, then it would be a third party trust. And it protects all of the assets in the trust. Now, these are all those assets we talked about in, I think, 2 or 3 videos back, your home, your car, things along those lines. So whatever you transfer into that trust is what's protected. Anything that's not in that trust is not protected. The benefits of doing this is you get protection from creditors and litigants. You have the potential to get multiple SALT tax deductions, and we'll go into that in more detail later, but basically what a SALT tax is it stands for state and local tax, and that's things such as income tax paid to your state and property taxes on your home. There's some other things, but we'll get into that in more detail. There is a $10,000 cap on SALT deductions. So by setting up another irrevocable trust, you could get another $10,000 SALT deduction and so on.
Oh, that's huge.
It is huge. It's very difficult to do because there's a lot of rules that make that valid. And if you don't follow all those rules, then you can't get that second deduction. But it is a definite benefit of setting up an irrevocable trust.
Right. Yeah. No, I'm always amazed at the value you bring every time we sit down. I learn something new. Doubling your SALT deduction is big. So.
Well, here's another one.
Yeah.
You have a potential to eliminate state income tax. If you live in a state that has income tax and you have assets that are not physically bolted down to the state, such as real estate, then you could set up an asset protection trust in another state and then pay the state income taxes in that state. Well, if that happens to be a state that doesn't have income taxes, then you don't pay any state income taxes on those assets.
Right. Wow. That's huge.
Yeah. Once again, we'll talk about all these tax themes in a lot more detail later, but a step-up in basis is when somebody dies and they have assets in their name, any capital gains that has collected during the time that the person had that asset, if they were to sell it before they died, they would have to pay capital gains taxes. But if they die and pass it on to their heirs, all of the capital gains taxes get erased to the heirs. And if the heirs were to sell it one day after they died, they would owe no capital gains taxes. Mm-hmm. By using an irrevocable trust, typically you lose that benefit, that step up in basis. However, if the trust is set up properly, you can actually retain that benefit as well.
Wow. Yeah, these are mind-blowing stats. Hopefully you guys watching at home taking notes and getting ready to call Phil tomorrow because these are massive. We're talking big money here. So,
and actually, I'm glad you said that. Please do call tomorrow because the way that without going into too much detail again, the way that the tax laws work is currently we have a very favorable tax environment here in 2020. In 2021, because of the change in the presidency and some of the different congressional positions, there's a possibility that the tax laws may may change considerably.
Yes.
If they change the tax laws at any point in time in 2021, they could make it retroactive back to January 1st of 2021. So if you want to take advantage of this year's tax laws, you have to have a plan in place, signed and done by December 31st of 2020. Otherwise, you're going to be subject to any potential new tax laws that may be passed next year.
Right. Well, I take that back. Don't call tomorrow. Call today.
Yeah, absolutely. While we're on that topic, these irrevocable trusts can be used to reduce your taxable estate. And that's part of what I was just talking about.
Wow.
And then the one thing that every trust provides is it avoids probate, at least in the state of California and in most states in the US.
Right, which is that messy process that we talked about. I think it might have been the first time we sat down together, we talked about probate. So
more than likely,
a while back.
I think that's one of my number one topics that I speak to people about, because a lot of people don't understand what happens when you pass away.
Right. Yeah. Always got a plan. Plan for
but look back to that video and refresh your memory if you don't remember what a probate was.
Absolutely.
All right. So the downsides to an irrevocable trust is it usually has to be part of your estate for estate tax purposes, or you have to use up part of your gift tax exemption to get it out of your estate. It's not always the case. There's other ways to do it, but that's typically one of the give and takes there. Like I said, unless you do a third-party trust, you as the creator of the trust cannot be the beneficiary. In other words, the owner of the trust. So if that's a concern, then you want to do the third-party trust.
Okay. In the gift tax exemption, we'll probably talk about it some other time. Quickly, what is the gift tax exemption?
So the gift tax exemption is, I'll talk about current, okay? So it fluctuates with time, but currently as an individual, you can gift $15,000 to each other individual that you want to in any given calendar year, and you don't even have to file a return for it. Right. So for instance, if I wanted to give $15,000 to my 5 children, if I had 5 children, I could give $15,000 to each of them, and I could give out $75,000 without reporting it. If it's over that $15,000 a year per person that I gift to, then I have to report on my gift tax return what that amount was. Now, when I do that gift tax return, I have a couple of options. I could either pay the gift tax at the end of that year when I do the return, or I can use up part of my lifetime exemption amount. That lifetime exemption amount is actually referred to as the estate tax exemption. Currently, that is a little over $11.5 million. And so let's say I had to do a gift tax return and file it, and that was for, say, $3 million. And I die and I have, say, $10 million. Well, the 10 million is under the 11.5 million estate tax exemption, but you also add that 3 million gift that I did during life and didn't pay taxes on. So now that in the eyes of the IRS, it's 13 million. And then my estate would be paying estate taxes on about $1.5 million.
Okay. That's interesting. Lifetime exemption. I hadn't heard of that.
Yeah, it's a very, very common planning technique for some of the higher net worth individuals. I'll go into it more in another video, but that 11.5 million number is just the last couple of years. It hasn't been anywhere near that ever in the history of the U.S.
I see. Interesting.
Well, except for 2010 later, when there was no gift tax, but that's another anomaly.
Right.
So yeah, we'll talk about that later. Anyhow, back to domestic asset protection trusts. So you can do an asset protection trust in any state. However, there's really only 15 states that are considered domestic asset protection trust states. And that is because those states have a lot of favorable court decisions saying that these trusts are 100% respected and that creditors cannot get through them if they're done properly. There's other states, like the state that I'm in, California, that doesn't have those decisions or has negative decisions that says we'll pierce through your trusts whenever we want to.
Oh, wow.
So if you really want the highest level of protection, you need to pick one of those 15 domestic asset protection trust states. The problem with doing that is you have to have the trustee of that trust be in that state. You also can't, and so you also can't put another state's real estate in another state's domestic asset protection trust. So if you're trying to put real estate in there, that trust has to be set up in the state where the real estate is. So some challenges to doing it in other states.
Right.
If you can do it in one of those asset protection trust states, great. If you can't, there may be some other things that can be done to strengthen the trusts, or maybe add in like LLCs or some other types of plans and put them all together as a comprehensive plan to get you that asset protection.
Right. And if your brother just happens to be moving to New Hampshire, Vermont, or whatever state it is, then maybe you can make it work, I guess.
Absolutely. And then not to make things more complicated, but if I in California decided to set up a Nevada asset protection trust, Nevada is a domestic asset protection state. It's actually one of the top used ones here in this area. But if I were to set up a trust in that state and I am a resident of California, there are some conflicting case law throughout the country that says if you're not a resident of the state that you set that trust up in, you may not have those domestic asset protection laws apply to you. Now,
Okay.
Nevada actually isn't one of those. You can set one up in Nevada and get the protection if you're out of state, but some of the other states have that issue. So it's really important to talk with somebody that knows about asset protection to let you know what state you should be setting that trust up in.
Right. So many moving parts. Yeah. It's crazy.
Absolutely. So that's basically it for domestic asset protection trusts. They can have any provisions in them that you want. Things can go where you want them to. The income tax generated or capital gains tax generated on the assets can be taxed to the creator, the beneficiaries, whoever the case may be. And so you can really play around with those. They just need to meet some certain formalities.
Right. And they require a lot of planning.
Yep, absolutely. The second type of asset protection trust that I want to talk about in detail because they're pretty common is something called a spousal lifetime access trust, or also known as a SLAT, S-L-A-T. Again, it's another irrevocable trust, but instead of setting it up to benefit yourself or some third party, it's actually set up to benefit your spouse. So this is obviously for people that are married. Now, if you're not married, or if you don't want to do one for your spouse for whatever reason, they do have a kind of an offshoot of these called a RELAT, and it's a relative lifetime access trust. So you could do it for a close relative as well. One of the things that is a big consideration with a SLAT is what happens in case of divorce. If I say I'm setting up this trust and this trust is only for the benefit of my wife, and 10 years later, my wife and I get divorced, then all those assets belong to her and they're no longer mine. So I just lost out big time.
Wow.
So you can do one of many things to make sure that that's protected. One of the most common ways to say is, rather than name your spouse individually, you say that it's for the benefit of my spouse. And then if I get divorced, my next spouse can step into those shoes.
Wow. There's a lot of different things you can do.
Absolutely.
Got to be prepared, I guess.
And then just like the domestic asset protection trust, it'll protect all the assets that are in the trust, not ones that are not in the trusts. Again, just like the domestic asset protection trust, you get all the same benefits: protection from creditors and litigators. You can have the ability to get multiple SALT deductions, potential to eliminate state income taxes, potential for that step up in basis, potential to reduce your taxable estate, and then again, it avoids probate. The downsides are very similar again to the domestic asset protection trust. They must be part of your estate for estate tax purposes, or you're using up that gift tax exemption, and the creator cannot be the beneficiary. Now, one of the other challenges with a spousal lifetime access trust is the easiest way for people to think about this is, well, me and my spouse, we own everything equally, 50-50. So I set one up for my wife, and my wife sets one up for me, and we put half the assets in each trust, and then we still have the same half assets. Fortunately, there's a lot of rules that say you can't do that. It's called the multiple trust rule, and you have to avoid the multiple trust rule when doing that. There's many ways to avoid the multiple trust rule, but some of the most common ones are having different beneficiaries, different trustees, having them in different states, having them set up at different times, things along those lines. And the more of those factors that are in there, the less chance that you're going to fall susceptible to the multiple trust rule.
Okay, so if you're married, then the law wants you to just have one trust, or?
Well, they don't want to see, the IRS especially doesn't want to see that you've set up multiple trusts to try to take advantage of multiple tax laws. So for instance, the SALT tax, if you set up 20 different trusts, you don't get $200,000 in SALT tax deduction instead of the 10,000. Those 20 trusts all have to be each individual unique trust rather than duplicates of each other just to get that deduction again.
I see. So there's ways to get these things done and get these benefits. You can't just be very blatant about it. I guess seems like the IRS puts these boundaries where you can do this and you can do that, but you have to do it the right way. Otherwise, you're going to be seen as taking advantage, I guess.
Absolutely. And then there's other types of trusts out there. There's GRATs, which is a grantor retained annuity trust. And that's one where you could have an income stream for yourself. Those are good for certain tax strategies as well, but also asset protection. A QPERT, which is a qualified personal residence trust, which is a great way to protect your personal home. Something called an ILIT, which is an irrevocable life insurance trust. The irrevocable life insurance trust is really important. When I spoke a minute ago to that lifetime exemption of a little over 11.5 million, they not only add in your gifts over life, that 3 million that I was talking about in that scenario, plus the 10 million that I had at the time that I died, but they add in any death benefit from your life insurance. So if I had an additional $5 million in life insurance policies, now my net worth is 18 million and we got a big tax problem. So you can put the life insurance into something called an ILIT and have that out of your estate so that it is not counted at the time of your death.
Wow. Very cool.
Yeah. And there's many other types of trusts, but those are the most common.
Yeah, sweet. It sounds like we hit all the big acronyms. We got them all down, and We'll leave some notes again at the bottom of the video for you guys to follow up with Phil. We'll leave his phone number, his email. He's a treasure trove of information, and he's doing free consultations for all of our viewers. So remember, if this is still 2020 and you're watching this, reach out as soon as possible so you can take advantage of the current tax laws.
Absolutely.
Well, thank you so much, Phil, for joining us today. To everyone at home, we will be leaving Phil's information, phone and email in the bottom of the video so you can reach out to him. If it's still 2020, make sure you reach out ASAP so you can take advantage of all the 2020 tax laws. Thanks again for watching the video today. And if you got some great information, please give us a like and a comment. Share it with your friends and family so that they too can get this information. And we will see you next time on the QX Financial Podcast.
Thanks for having me, guys. And don't forget to join us next week when we'll talk about more types of asset protection.
Looking forward to it. Thanks, Phil. The commentary provided in this video is for informational and educational purposes only. No advice, offer, or solicitation of any kind, expressed or implied, is being given. The views and opinions expressed do not necessarily represent the views and opinions of QX Financial, any subsidiaries, or associates thereof. When considering making any changes to your situation, you should consult a competent licensed professional. All rights reserved. Copyright September 17th, 2020.
This information is not intended and should not be taken as legal advice for any particular set of facts or circumstances. You should contact an attorney directly for advice with specific legal problems. None of this information creates an attorney-client relationship with the law offices of Phil Shekerlian.